Good morning, everyone. Myself, Priya Mohindra from Arya College Ludhiana, Department of Commerce. My today's topic of discussion is Memorandum of Association, its contents and alteration. So let's start with the topic. First point is meaning of Memorandum of Association. There are mainly three main documents of company: Memorandum of Association, Articles of Association, and Prospectus. But in this topic, we will talk about the Memorandum of Association. Memorandum of Association is the main document of company, which is why also known as Charter of Company and Constitution of Company. It will state all the objectives or powers of company which a company can perform from time to time. It will define the relationship of company with the outside world. No company can do any activity which is not mentioned in the memorandum of association. If any activity performed beyond the scope of MOA will be considered as ultra vires the activity. Therefore, it is said that it is the main document of company which must be framed very carefully at the beginning of the company. Next, we'll talk about the definition of memorandum of association. As per section 2, subsection 56 of Companies Act 2013, memorandum means memorandum of association of company originally framed or altered from time to time according to previous company law or according to the current company law act. Thus, a memorandum of association is any document which sets out the constitution of company, which clearly define the relationship of company with the outside world. Any document which defines the scope of activities or which will let us know what company can do or cannot do, that document is considered as memorandum of association. Memorandum of association enables the shareholder, creditor, or we can say all the outsider parties who are dealing with the company to know about the range of activities which a company can perform. There are few features of memorandum of association which we must have to keep in our mind. First one is it is a fundamental document of company which is required at the first stage of incorporation of company. It is the main document of company. Every company must prepare its own memorandum of association. The next feature is memorandum of association must be in written form. It will contain name, signature, and all the other particulars of person. On registration of memorandum, company is deemed to have been registered. It will contain information regarding the company. It is a public document which can be inspected by anyone for gathering the information about the company. It will bind company and its members. Next topic is clauses of memorandum of association. These clauses are also considered as contents of memorandum of association. Basically, there are 6 clauses which are name clause, subscription clause, capital clause, liability clause, object clause, and situation clause. These all clauses will define different things regarding the company. Section 4 deals with the clauses of memorandum of association according to Companies Act 2013. The very first clause is name clause, which is dealt under section 4, subsection 1 and subclause A. Name clause of company will tell us about the name of the company. It will state the name of company. Every company is free to select its own name as it likes, but the name should not be identical with the name of another company. It cannot use words like king, queen, emperor, etc. Name of company with the last word limited when we are forming a public limited company, and we have to use the word private limited at the end when we are forming private limited. Second clause is registered office clause. Registered office clause will let us know about the state or the place where company's registered office is situated. It is must that we have to mention the state where the registered office is located. Registered office means a place where all the common seal or statutory document where all the documents or common seal is kept by the company. Company should intimate the location of registered office to the registrar within 30 days from the registration or incorporation of company. The registered office of company can be shifted from one place to another within the same town, from one state to another state, by passing different kind of resolution, that is ordinary resolution or special resolution. We have to mention the address of registered office on our all legal documents like bill books, checks, letterheads, etc. In case of default, we have to pay penalty of rupees 1000, which cannot be more than 1 lakh rupees. Third clause is object clause. Object clause of memorandum of association will talk about the objective of company or powers of company which company can perform in its lifetime period. Object clause is further divided into two parts. First one is objective to be pursued while the incorporation, or all the other matters which it can take off after its incorporation. Fourth clause of Memorandum of Association is liability clause. Liability clause will talk about the liability of shareholders or members of company. The liability of shareholders or member of company can be limited or unlimited. In case of unlimited liability, the shareholder can be held liable much more than the value of share he has invested in. Moreover, unlimited liability can lead to personal liability also. But if the liability of member is limited, it can be limited up to the shares or limited up to the guarantee. If the liability of member is limited up to the guarantee, then whatever amount is guaranteed by them, they have to pay only that much amount. But if the liability is limited up to the shares, in that case, whenever liability arises, whenever loss arises, the shareholder will be liable to pay up to the unpaid amount of the face value of share. Fifth clause of Memorandum of Association is capital clause. As we know, for running any kind of business, we need finance or we need capital. That is included under the capital clause of Memorandum of Association. This clause will specify the authorized capital of business. Authorized capital is the capital which is required by company in its whole lifetime period. There are two type of companies, private company and public company. In case of public company, we require minimum capital of 5 lakh rupees for its formation, whereas in case of private company, earlier we need minimum capital of 1 lakh rupees, which is no longer required now. The amount of capital with which a company have to be registered is left on the discretion of those who are promoting it. Money borrowed on debenture don't form part of capital of the company. Last clause of Last clause of Memorandum of Association is subscription or association clause. This clause contains the name of signatories to the memorandum. The memorandum of association should be signed by at least 7 members in case of public company and 2 members in case of private company. So, the next main topic is alteration of Memorandum of Association. There are different clauses of Memorandum of Association which must be framed very carefully at the beginning itself, as it becomes very difficult to alter them later on because the process of alteration is very lengthy and complex. But still there are few provisions which can be followed for altering the Memorandum of Association. So the first one is alteration of name clause. We can change the name of company by two ways, that is by passing special resolution and by passing the ordinary resolution. For passing special resolution, this type of resolution is passed when we have to obtain the approval of central government in writing. No approval is required whenever we want to delete or add the word limited or vice versa. By ordinary resolution, when according to central government opinion company's name is too identical with the name of other company, it can change their name by just passing ordinary resolution with previous approval of central government, which signifies in writing. Next alteration can be done regarding registered office clause. We can change our address of registered office within the same city from one state to another state or within the same state. Whenever we want to change the address of registered office within the same city, company can make a change in the registered office within the same city, town or village by passing a resolution of board of director. Such change must be brought to the notice of registrar within 30 days. In case of default, rupees 1000 fine will be charged for per day. The registered office address can be changed within the same state as well. Change in registered office from one city to another within the same state would require passing a special resolution in journal meeting, which must be informed to the registrar within 30 days. Whereas we can also change the registered office from one state to another state, notified to the new registrar within 30 days of shifting to the new office. Next, we will talk about alteration of liability clause. Liability clause can also be altered. The liability clause can be altered only when public company is converted into private company. We can increase the liability of members only if they are willing to do so and provide their consent in writing, either before or after the alteration. We cannot decrease the liability of members. This will require the following: authorization of articles of association, special resolution of company, written consent of all the affected parties. The last one is regarding the alteration of capital clause. Section 61 of Companies Act 2013 provides for alteration of share capital, whereas Section 62 provides for increase in share capital. A limited company having a share capital may alter its capital clause subject to provision of articles by resolution in general meeting. The confirmation of court is not required in following purposes. For example, if we want to increase the share capital, we don't require the confirmation of court. To consolidate and divide its capital into share of larger amount. Whenever we want to convert our shares into stock and reconvert our stock into fully paid up shares. Shares are converted into stock when they become fully paid up. For this process, we don't require any kind of confirmation from the court. Whenever we want to cancel the shares of company, or we can say forfeit the shares of company, we don't require any kind of confirmation from the court. So, in the nutshell of this topic, Memorandum of Association is very important document of company, without which company cannot perform its activities, as all the powers or scope of activities are mentioned in Memorandum of Association. It is also considered as charter or constitution of company, which can be inspected by public, as it is a public document also. Whenever outsider parties will inspect the memorandum of association, it will become a public document and also a part with the help of which they can invest their money into the company. So it is very important for every company to properly frame its memorandum of association. Thank you so much.